Kelly and Mr. Norton. And Mr. Kelly, you may proceed.
Thank you, Your Honor. May it please the court. Good morning, Your Honors. Matthew Kelly on behalf of the petitioners, Greenspire Global and Steve Knaus, individually. And Your Honors, I'd like to reserve 5 minutes for rebuttal.
Very good.
Thank you. So just to begin, this case, the underlying case, is a case about ingredients of certain proprietary products belonging to Greenspire Global. In the complaint, the second amended complaint, it alleges misrepresentation about ingredients and the organic nature of Greenspire's products, allegedly licensed to the respondent SGG, Sarasota Green Group, who I'll refer to as SGG, under an alleged exclusive license agreement. The issue before this court today is whether the trial court departed from the essential requirements of the law in ordering production of Greenspire's proprietary formulas and testing of its product over many years, which are trade secrets of Greenspire.
This all goes back to the requirements of the federal statute, correct?
That is what has been alleged. So there's the Federal Insecticide, Rodenticide, Fungicide Act.
And that statute would require more than just a listing of ingredients to determine whether these are prohibited products. Is that correct?
So the respondent has made that assertion in the response, and as I say in the reply, we do dispute the extent of that. So what we would argue about FIFRA is essentially FIFRA provides a list of ingredients that are exempted from certain regulations under the EPA, and if you use those ingredients, your product is exempted. Now the issue in this case is that there were two ingredients that were not exempted, and therefore made the product violate the FIFRA requirements. So we're just talking about ingredients. The aspect of the response that claims that you have to work in your formulas and things like that, and therefore it's relevant, I do want to point out that none of this was brought up in the trial court. So we did not have an opportunity to respond to that. And that really is the issue here on our petition.
Did you address in the trial court the statutory framework that is required by FIFRA?
We did not specifically address.
Doesn't that statute, as Judge LaRose pointed out, doesn't that statute require that every pesticide registered with the EPA administrator includes disclosure of complete formulas?
Yes, for FIFRA though, the issue in this case.
Well, if FIFRA has it and there is a notice issued that your product does not comply for purposes of exemption, then tell me why the other side isn't entitled to see what formulas you registered and what formulas you're using that support the contention that I guess the analysis was wrong and that you should be exempt.
So because the violation notice that was issued in this case, and that was included in the supplemental appendix filed by the respondent, lists the two ingredients that were allegedly identified that made it not compliant.
Which presumably your client disputes, right?
Correct.
So wouldn't the formula itself, rather than a list of ingredients that you contend are in the formulas, wouldn't the formulas itself be the evidence that goes to whether or not you complied with the legal requirements?
Well, we don't believe it does, and let me explain why.
And a confidentiality agreement was entered into by the parties and approved by the court, right?
That's correct.
Okay, go ahead.
So does that confidentiality, remind me, does it have a counsel eye only provision?
It does. I mean, it's a confidentiality provision that protects some.
That would have such a provision, right? Counsel only.
Does. Yes.
It also says the parties and anybody who needs to know in the parties, right?
Right. That's correct.
Not a strict attorney's eyes only.
That's right. I apologize for that. That's right. It is a bit broader than that, and because that is a primary argument made by the respondent, but the confidentiality agreement was entered. It does not constitute a waiver. There are many confidential issues in this case, including ingredients. Some of the things we've produced are how the ingredients evolved over the years. That would be a trade secret.
Let me ask you shift gears on a question for you. Wasn't the trial court required to either conduct an in-camera review or have a hearing, an evidentiary hearing, to determine not just whether the requested information was a trade secret, but also the reasonable necessity of its production.
Yes, absolutely, Your Honor, and that is the main thrust here of our petition. The trade secret nature of the products is not in dispute. That was contended in the trial court and in the response that they are in fact trade secrets. So we kind of dispose of that in-camera requirement. But at the hearing, the party seeking disclosure was required to provide the court with or carry a burden to show that it had a reasonable necessity for the disclosure. And in this case, that simply did not happen. And, we could talk about the issue of FIFRA and whether it's, the formulas have to be disclosed and what has to be disclosed. But the problem is that we were robbed of the opportunity to address that in the trial court. None of that at all was raised in the trial court, not in the motion, not at the hearing, never, not at all. The first time it was raised was in the response. Okay, and that's the problem. That's why we're seeking this writ. And, to go back to the formula versus the ingredients issue, that's the judge kind of conflates the two. And I use an example of Coca-Cola. Okay, on a Coca-Cola bottle, the ingredients are on the label. So they're known. Everybody knows the ingredients. The formula, though, is one of the most protected trade secrets in the world. Nobody knows that except Coca-Cola.
Well, keeping with the evidentiary hearing question, did you ask the court or object to the failure to conduct an in-camera review or an evidentiary hearing?
We did not specifically request an evidentiary hearing on this issue. It was the burden of the respondent to establish their reasonable necessity, whether they were able to do that with argument or via an evidentiary hearing. It simply did not happen. There was not even an argument made about the need for this information, not any argument at all. In response, we argued that they had no need for this information, and we attempted to argue the distinction between formulas and inspections, but that didn't happen. So there was a burden here that belonged with the respondents to carry, and this court has said that is a high burden, and it simply didn't happen.
You don't dispute that the burden can be met based on the pleadings and discovery of record, and an evidentiary hearing may not be required. I mean, you don't dispute that, do you?
I do not, but the burden would require the court to find that the information was necessary to prove something in the case, and it's not. Now, again, like Your Honor brought up, there is the issue of FIFRA, which was raised for the first time in the response, but we should be provided the opportunity to respond to that and to address what it is FIFRA requires.
There was a hearing in front of the judge, and you had the opportunity to argue the reasons why this information was not relevant or likely to lead to the discovery of relevant evidence, didn't you?
Yes, and we did argue that. We argued that.
And the judge made a ruling. The judge decided, no, I think there's enough here. The entire lawsuit is grounded on this idea of what is in this product, and basically why was there a notification issued that the product doesn't comply because it has non-exempt components. And so your client's contention is, doesn't have non-required components. Here's our list of ingredients. There's a disconnect there, right, between what your client contends and what the notice says. And so isn't that exactly the reason why the court said, we need to see exactly what's in here. I want to see the formulas. I want to see the tests and so forth, or that the other side is entitled to see that. I mean, isn't that essentially what the court did based on the pleadings and the documents of record?
Yes, but the issue is that the pleadings don't say anything about formulas. This isn't a case about simply ingredients. And what we're talking about with a formula is we're talking about the amount of each ingredient, the composition of the ingredients, the testing, the way it's produced. We're talking about a lot of information that has no bearing on the outcome of this case, because this case is about whether or not there were ingredients that were not exempt under FIFRA.
So I want to make sure I understand that your position is that as long as we list the ingredients and those ingredients do not include something that is problematic, case is over.
Well, yes and no, because I think it's a little more nuanced than that.
So everybody's got to take your client's word for it as to what is in the product and what the formulation is. And the reason the formulation seems to me to be significant is there might be a insignificant amount of a product that is not exempt. And that may or may not be a problem, but the formula as to how much of that product is in there could trigger the needle to move far enough to where the FIFRA says, no, this doesn't qualify.
Well, no. So actually the way FIFRA works is if a product that is not exempt is in it, it is not an exempt product in any amount. And that's what the violation notice says. It identifies specifically two ingredients, that are alleged to be in the products that are not compliant. Now, as to whether or not it's just about whether or not it was in there, this is a case for fraud, essentially, and that fraudulent misrepresentations they allege were made by my client.
Which is what is alleged.
That's right. That is what is alleged. So it isn't just about whether or not that's in the product. It's about knowledge about whether it's not exempt. It's about when those products or those ingredients were deemed not to be exempt under FIFRA. It's about some other issues.
Let's assume for the sake of argument that your client believes there was no problematic ingredient in there. Then wouldn't the formula, whatever it is composed of, and whoever puts that formula and the product together, wouldn't that tell everybody that there is or there isn't a non-disclosed product in there?
Well, the ingredients would tell that, because if there's an ingredient in there, and it doesn't matter the amount of the ingredient, it doesn't matter how the product was made, it doesn't matter the years of proprietary testing that my client has undergone with these products, none of that is relevant to the issue that the plaintiffs are going to seek to prove in this case, which is whether or not.
So if the proprietary testing supports the plaintiff's cause of action and your client wishes to hide it, your position is they're entitled to hide it.
Well, my client is entitled under 9506 to protect its trade secrets from a competitor. I mean, we are talking about an industry competitor here. And what the court has done is ordered my client to hand over all of his products, all of his research, all of his testing over years of building this company to a competitor in a case where their allegations can be proven simply on whether or not there's an ingredient in the product that's not exempt under FIFRA, and they have that information. I mean, it's about how extremely prejudicial this is to my client. I mean, this is ordering Coca-Cola to provide its proprietary formula for manufacturing its product to RC Cola or any other cola company in the country. That's what was done here. And it was done without an opportunity to address any of these allegations about FIFRA and whether it would actually be relevant. It was done in the way exactly the case that I cited, the Seacoast Fire case versus Triangle, which is on a whim. That's what happened in this case. The respondent made no arguments in the motion, made no arguments at the hearing about why this information was necessary, and the court, in a pretty quick hearing, went through some of the allegations and said, well, it could be in some way, and we didn't have an opportunity to respond to any of that. And what essentially happened is the burden in this case was put on my client to anticipate arguments about relevancy from the respondent and then rebut that. We haven't had that opportunity. This should be quashed, and if necessary, it should have a hearing where we can address these issues that have been raised about FIFRA. But there is a significant distinction between ingredients and formula that that the judge kind of conflated the two, and we really haven't had an opportunity to address. But it is a significant difference, and the outcome of this order is very prejudicial and damaging to my client. I mean, it could render these things valueless, and a confidentiality order is not going to protect that. The know-how and the knowledge of how to make these products, what goes into them, how much of each ingredient you put in, when all they need to know is the ingredients that are in them. And
let's talk for a minute about the financial information. Your opponent says that the reason the financial information is necessary is to defend Mr. Knaus, his jurisdictional challenge. I don't know where you are on time, and you may want to address this on rebuttal, but before we go through everything having to do with the formula ingredients issues, I did want to address the financial discovery issues.
Yes, thank you, Your Honor. So yeah,
And
that,
Mr. Kelly, just so I'll let you know, you've got about half a minute on your original 15. So go ahead and answer the question. And if you do so fairly succinctly, then you'll have your full 5 minutes for rebuttal.
thank you, and I'll do my best to do that. So the issue on the financial, they're essentially requesting K1s, W-2s, personal financial information of my client. Again, it has nothing to do with the allegations of their complaint. The jurisdictional issue has been ruled on. I know an argument was made in the response that somehow those are relevant to the jurisdictional issue, which has been raised as an affirmative defense. But again, we're talking about personal financial information of my client, and we haven't really had an opportunity to address that. It's not relevant to the allegations of the complaint, which pertain to an exclusive license agreement and the ingredients we've been discussing.
I'm sorry, did you say the jurisdictional issue has been ruled upon or has not been?
Well, the circuit court has determined that it has jurisdiction in this case.
A personal jurisdiction.
Personal jurisdiction, correct.
Okay, so are you contending then that the financial information is now moot?
Yes, it is now moot that it's been ruled on, but additionally, we haven't, as it's sort of with the formula and the ingredient argument, we haven't had an opportunity to respond to that because it was raised for the first time, in the response to our petition, the connection between that and personal jurisdiction.
Very good, thank you. Mr. Norton?
Yes, Your Honor. May it please the court, Hunter Norton on behalf of the appellee, Sarasota Green Group, LLC. I want to first touch on what Judge LaBrette initially asked, which related back to the trial court's obligation to host an evidentiary hearing.
Before you go to that,
Go ahead. Sure.
Is the financial information now moot?
No, it's not. Let me explain why. There was a full day evidentiary hearing on a motion to dismiss for lack of personal jurisdiction. The defendants or the appellants here lost. The court found it did have jurisdiction. Then when they filed their answer to the second amended complaint, they nevertheless asserted it again as an affirmative defense and also asserted the corporate shield doctrine as an affirmative defense.
So the affirmative defense and those issues have not been resolved on summary judgment or otherwise.
That's correct.
All right, go ahead then.
Yeah, and that also brings me full circle back to where I was beginning, which is the court here did have a full day evidentiary hearing to resolve that issue and determine whether or not it was more likely than not that a tort had in fact been committed if proven out in the state of Florida and specifically Manatee County. So the court was eminently familiar with all of these issues, including the FIFRA issue, all of the players, the central issues in this case, which are whether or not there was a fraudulent representation made by the defendants to my client concerning the formulas and organic properties of these products. So the court was very, very familiar, and I point that out.
Let me ask you a question. Was that hearing before the hearing that we have a transcript from the hearing on the motion to compel? I don't believe we have a transcript of anything else. It may have happened after the motion to compel hearing.
It was before the motion to compel. So
okay.
The court was eminently familiar. And the reason I point that out.
Do we have it in our record though? Because I didn't see it.
No, it's not in the record. I have to.
So at this point, you really can't be arguing things that aren't in the record. Whether it should be in the record, whether it should be in the record or not is a different issue, but it's not now. So
sure.
Go ahead with your argument.
Sure. The point being that the Suncoast fire case that they're relying on here. So in the case it relies on, which is Beck Dumas, they both say the same thing. They're saying that the court doesn't need to have an evidentiary hearing on reasonable necessity if one of two things happens. Either the court's eminently familiar with the issues, which here the judge was, or two, if there's really no issue in fact. And that's really critical here because I'm hearing that, well, FIFRA is raised for the first time in the response. That's not correct. FIFRA is set forth specifically in our second amended complaint, and I would direct the court to the record on this. It's at paragraph record 10 at paragraph 29 of our second amended complaint, where we allege specifically that these products were represented to us to be compliant with FIFRA, and they were not compliant with FIFRA. That's the whole point of this. And with respect to so when we get the notices telling us that there's two ingredients here that bring you within the auspices of FIFRA, and therefore these products are not compliant, That's when this lawsuit began. We then get, as you can imagine, in a fraud case, we get responses denying the allegation that, right, they deny it. They don't admit that these products violate FIFRA, they deny it. Then they tell us, well, we're giving you all of the ingredients, but they don't. What they give us are just the labels to the products. The only way that we know what's actually in these products is, one, knowing what they're telling us the formula is, two, whether or not that formula was actually tested, and three, the testing is also important for another critical reason here, and that is whether or not they had knowledge that these products were not FIFRA compliant. Because if, as we suspect, these products contained non-exempt ingredients and they're not FIFRA compliant, that would have been determined through testing, right? So I would imagine, as in any fraud case, I'm going to hear as we go through this that I had no idea these ingredients were in there. Well, to prove that out, I need to see your testing results, because I'm imagining at some point along the way, someone told you, hey, you have non-exempt ingredients here, you need to comply with FIFRA. That's our suspicion, and that's what the reason we need these to prove that. So
let me ask a question on that. Assuming that we agree you're entitled to testing results, why are you entitled to the exact formula, which has every ingredient and percentages and how you do it and so forth? Why is that reasonably necessary as opposed to whatever testing results may exist?
Yeah, so Judge Silberman, you actually keyed on it earlier, and I have to respectfully disagree with the counsel. I was concerned that what I would hear is what you asked earlier, is that, well, yes, there is this one non-exempt ingredient in there, but it's only at 0.00001%, and therefore it's not within the auspices of FIFRA. So that was my concern, is that because FIFRA is going to require at least certain amounts of these ingredients, that I need the full formulas to determine that. And also, quite candidly, I would like to ask the FDA if this is FIFRA compliant, which requires us to go to the FDA with the formula. And not only the formula, I would also note that if you read through the entire FIFRA statute, which is extremely lengthy, they're also reserved the right to ask for all the testing results. And I imagine that the reason that's in the statute is the same reason I want to hear whether or not they are aware of what ingredients are in their product, and so that the FDA has that at their hands if they request it. But the formula certainly is required to be produced to comply with FIFRA. And because it was represented that these products are exempt from FIFRA, and we determined that no, actually they're required to comply with FIFRA. To comply with FIFRA, we need this. I would also point out one other thing. I've heard several times that we are a competitor, and while that may now be true, remember the position of these parties when this deal was struck. We were the exclusive licensee of these products. It was our job to manufacture and sell these products for the manufacturer, for the defendant's benefit. That was the whole purpose of the exclusive license agreement here. So we were not, prior to this, competitors. We were working together. And the fact that someone tells us these things to get us to enter into a license agreement, which turns out to be fraudulent, and now you're telling me I don't have to tell you what the formulas are because they're trade secret, and even though we've entered into a confidentiality agreement, you still don't get them. Well, obviously 9506 disagrees, saying you can't shield your own fraud by arguing that these are trade secrets, and that's effectively what's being done. We immediately recognized that we were dealing with trade secrets. There's no dispute there. We immediately suggested and negotiated out a confidentiality agreement. It's for attorneys' eyes and also experts' eyes, obviously, as may be needed to determine whether or not these products are or are not compliant with the federal regulations, FIFRA. So it's not as though these will be handed down to our client to use and manufacture. And even Judge Nicholas noted that at the hearing, and it's in the transcript where he said, I would come down very, very hard on that. I don't expect that would happen here, but I would come down very hard on it. But Judge Nicholas, in making his ruling, noted that this issue, the ingredients and the testing and the knowledge, that was, his words were, it's the heart of the case. It's the ultimate question. That's in quotes. That was his words. It's the ultimate question in the case. And that's because not only from his knowledge of everything that's gone on in this case, but it's in the pleadings itself that these ingredients were mislabeled to intentionally omit these ingredients, that the ingredients brought the products within the auspices of FIFRA, and that they were intentionally misrepresented to us, both through oral statements and in the exclusive license agreement itself. So
let me turn to the financial information.
Sure.
You have alleged, your client has alleged fraud, which is an independent basis for jurisdiction in Florida, correct?
Correct. Under law, yes.
So because you have jurisdiction based on the allegations of the complaint, what is the purpose, what is the relevancy, and what is the necessity for the financial information relating to Mr. Canals?
Sure.
I mean, he purportedly committed a fraud in Florida. The case law and the statute give you jurisdiction, or the court jurisdiction over him in Florida. So what's the purpose of the financial information? And how is that well, there are really two parts to this question. How was that established to the court? And two, it doesn't look like the court addressed it in any way at the hearing. There was no discussion at the hearing about financial information. So I have to say candidly, I'm concerned about that, and I want to hear the basis to go forward to allow that discovery to take place.
Sure, and I appreciate the question, and you're correct. Neither party, notably the appellant here, did not raise that specific issue. And it
was a motion to compel. He had raised the objection, so it's teed up, and nobody talks about it to the court.
Right. I think other than a generic statement that in our motion to compel that they were relevant to the pleadings and claims and defenses of the parties. And in that sort of dovetails us into the first part of your question, which was, how is it relevant now? Well, I would tend, based on counsel's concession that the personal jurisdiction defense is now moot, then certainly that is off the table. But what remains on the table is the corporate shield defense, where what you have Canals telling us is that I was only there in a representative capacity of Sarasota Green Group, even though he was the only person there for Sarasota Green Group. It was strictly as a corporate capacity. If we are able to show through and I don't know that we'll be able to. That's the reason we're doing this in the context of discovery. If we're able to show, however, that Mr. Canals derived an independent financial gain as it relates to his misrepresentations or fraudulent conduct in Florida, then that corporate shield defense would go by the wayside. And we cited—
Wouldn't the corporate shield defense go by the wayside if there's fraud?
Yeah, well, but remember, there's cases, and we cited the Freehoff case among others in our response, where it was, in that instance, it was a corporate officer who was traveling to Florida strictly to, in their corporate capacity, derive no independent benefit from the fraud committed by the corporate entity there. And the court said, based on that, there is no, it was a jurisdictional question, but still there is no jurisdictional question because the corporate shield would shield the officer acting in that capacity. However,
was the officer in that case the officer who made the purported misrepresentations?
No, was not.
And so isn't that a distinction in this case where you have alleged Mr. Canals himself made those fraudulent statements on which your client relied?
Yeah, it is a distinction. It's certainly one of the numerous factors that we would like to argue, but it also should be supported by not only was he making it, he was making it so that he could derive his own financial gain, independent or as part and parcel with the company.
But again, I have to press the point. How is that relevant if he is the officer making the purported fraudulent statements? If I remember the discovery, he admits he is president, and he's got an ownership interest in the company. And I'm not going to swear to that, but I thought that was part of the discovery that you already have, that he admitted those roles. So if he's admitted those roles, if he's the guy on the scene who makes the misrepresentations, what more do you need for purposes of financial discovery?
Well, I would certainly tend to agree that that would go a long way towards defeating that defense, but I don't know, since they're continuing to maintain this defense and they're continuing to make these assertions that he's protected, I have an obligation to my client to explore all avenues, and certainly whether or not he had and exactly what his financial arrangement is with Sarasota Green Group, that I don't know. I do know that he's at least the corporate officer. I do not know if he also serves as an employee or takes a salary. I don't know that. I don't know whether or not he receives some sort of independent, as I've said before, financial benefit out of this transaction. I just don't know. Again, this is discovery in a fraud case, which, as we cited in our response, is certainly broader than typical discovery. This isn't something that I'm looking to go into just so that I can have a way of executing ultimately. In fact, it's protected also by the confidentiality agreement. So the purpose here is to at least explore, since they've raised this now as their affirmative defense, I think I'm entitled to at least discover any responses I might have in that respect. And that would include his financial dealings with Sarasota Green Group only for those years where he was in place, and in Florida and as restricted by the pleadings and the requests.
So your view is that his acknowledgement and his testimony and his affidavit that he is president and that he met as president of Greenspire with Mr. Cassidy and others, that's not enough to, assuming you can prove that what he said was fraudulent, you don't believe that's enough to defeat the corporate shield doctrine?
Oh, no, I think it is. I agree. I just don't know, but I could defeat an argument for 10 reasons. I just don't want to restrict myself to 9 of 10. I guess the easiest way to put it.
Very good. And you've got about 5 minutes left.
Okay. At this point, the only other issue that I was actually going to dovetail into the financials here, but the only other thing that I would note for the court is, again, I want to dispel the notion that, this was originally argued to the court, as I understood the defendant or the appellant's argument, as a sort of cat out of the bag defense. And we heard that again today with the analogy to Coca-Cola, which I would note that Coca-Cola is not bound to comply with the obligations of FIFRA. And that's what makes this different here. So this was originally positioned as sort of a cat out of the bag. The court and Judge Nicholas ruled that no, it goes to the ultimate question in the case. Discovery in a fraud case is certainly broader. It would include these things, again, not just, so that we understand whether or not it complies with FIFRA, although that is a significant portion of it, but also to establish knowledge on the part of the defendants that these products were not compliant and they were required to be compliant. What actions they thereafter took, that would spin into that, right? I find out that they were aware of, through testing results, that these were non-compliant, products that they needed to comply. I find out then that as a result of those testing results, they intentionally sent to manufacturers on labels incorrect labeling, which again is in our pleading. It's right. It's in our second amended completing that they intentionally mislabeled their products, and in doing so also misled us to enter into the license agreement. So again, because fraud is a different species, it certainly gives us an exemption under 9506 for trade secret. You can't hide behind your trade secret privilege to conceal your own fraud, which is what's being attempted to be done here. Also, the scope of discovery is much greater. So for those reasons, unless the panel has more questions for me, I would rely on our brief and ask the court to deny the petition.
Very good. Thank you very much. Mr. Kelly, you have your rebuttal time.
Thank you, Your Honors. So well, real quick on the financial information, we're not talking about a discovery request that's asking what is your relationship with Greenspire. We're talking about a discovery request that says any and all K1 and or W2 schedules that were received by you from Greenspire Global for calendar years 2017, 18, 19, and 20. So it's quite a bit more than what was being argued. They already know his relationship with Greenspire. They already know who the other owners of Greenspire may be. That information's all known. But I want to turn to the pressing issue of these trade secrets. The FIFRA argument that you heard here today is not in the complaint. The complaint only talks about ingredients. Okay, what's happening here, and again, I stress that this is the first time in the response and in today's argument, is that the formulas are being bootstrapped into the FIFRA argument. The FIFRA, the way it's pled in the complaint is about the ingredients, because if an ingredient is not compliant with FIFRA, the product is not compliant with FIFRA. They know the ingredients. We've answered requests for discovery requests about the ingredients going back several years, whether there's any ingredients that are not listed on the label. We've produced and provided all that information. Now we're going a step further and we're talking about formulas. And there is a very significant distinction between those two things that I believe that the trial court, failed to recognize. We didn't have an opportunity to respond to these FIFRA arguments in that setting, in an evidentiary setting, if the trial court thought one would be required. None of these arguments were made by the respondent. The word formulas did not come up in the motion. It did not come up at the hearing by respondent. We were the first ones to raise the issue of the formulas when that is exactly what the discovery requests are seeking. So how can it be said that the respondent carried a burden that this court has called a high burden when they didn't even mention why they needed this information, meaning the formulas, not even mentioned. And so, of course, we didn't have an opportunity to respond to it. It is a cat out of the bag issue. This court.
I'm curious about something. You said you didn't have a chance to respond to it. There was a request for discovery. There was a response to it and an objection, and then there was a hearing. So are you telling me that you didn't argue in defense of the objections that they're not entitled to the formula for X reasons?
Yes, what we didn't get to respond to was this specific new argument about why the formulas are needed because of the FIFRA allegations of the complaint. We did not get an opportunity to respond to that, and we dispute that. The formulas are not needed to establish their claim.
I understand what your argument is. I just wanted to make sure that, in fact, you had the opportunity to tell the trial court judge exactly that.
Well, we had the opportunity to argue our objections. We didn't have the opportunity to respond to an argument that was not made by the respondent about reasonable necessity. Their argument here.
I understand your argument.
Thank you, Your Honor. So this is cat out of the bag material. It's trade secrets. It's protected by the statute. This court has ruled that it's appropriate for certiorari review. The essential requirements of the law in this case required the court to have the respondents maintain a high burden of establishing their reasonable necessity for this information. That simply did not happen. The hearing was rather quick. It was cut short, and it was ordered because the judge felt that it may possibly relate to issues in the complaint. But it doesn't. It's significantly distinct from the ingredient issue. This is very damaging to my client. They're essentially handing over their company to a competitor. The alleged exclusive license agreement that was referenced by respondent never provided them this information. It was not something that was ever contemplated. Even in the alleged agreement they were going to have, they were not going to be entitled to this information that they're seeking now. And if they get it, they've got years and years of proprietary work that my client did to develop these products, and they simply don't need it to establish their case that these products contained ingredients that were not appropriate under FIFRA. And that's exactly what the violation notice says. It doesn't say anything about the formula. It identifies 2 ingredients that they claim were not compliant with FIFRA. So unless your honors have any other questions, I'll rest on the briefs.
Very good. Thank you both very much. That concludes the oral argument. All of a sudden, I'm getting feedback. That concludes the oral argument session for today. Again, thank you very much, and we are adjourned.
Thank you, Your Honor.
Thank you, Your Honors.